discovery rule.
Okay.
I do not believe it is implicated in anything we have here. And I think as we get to further cases that our Supreme Court's decided, you'll see that they work together. They're not inconsistent with one another. So no, ma'am, I'm not asking for any rehashing of the discovery rule.
Okay.
I'm simply asking that this court find that South Carolina law would recognize that contract claims that are based on violations that give rise to independent causes of action that occur within 3 years before suit is filed are in fact actionable, especially in an executory contract and especially in one that has a no waiver provision or a non-waiver provision.
Sorry, counsel, this is Judge Harris again. I'm just trying to really pin down what exactly is in front of us. If we were to agree with you that the South Carolina Supreme Court would likely recognize this continuing violation theory about fresh breaches, there's been no finding yet, right, that there were any fresh breaches. What we would do then is remand for the district court to figure out whether, in fact, you can show that there was a fresh breach within the 3-year limitations period.
I think you could remand, Your Honor, although I would point out that the court said if the court finds that a continuing breach is recognized, Polymed's claims alleging breach of the agreement would not be barred. So,
no, I thought she said, I'm sorry, I thought the district court said would not be barred on account of the fact that there were some old ones that fell outside the limitations period.
They did. They found that, so we're going to...
Right, so that's a different question.
That's right, and you can send it back, and the trial court can make that determination, quite frankly, on a motion for summary judgment based on the record before it, because not before this court, but the record before that court does show evidence of fresh breaches, and that part has not been...
I may be a little bit confused. This is Judge King, Mr. Brown. I thought you wanted us to certify the legal issue to the Supreme Court of South Carolina.
Well, Your Honor, understanding, I did ask for you to certify, and I'd like for you to certify if you have to certify. And I don't want to be particularly greedy. You know, growing up in South Carolina, they teach us pigs get fat and hogs get slaughtered. However, since this case was decided, a new case came out from our Supreme Court that the district court did not have the ability to review and determine its applicability to this issue. So I will make the sort of selfish argument that I believe there are enough cases now from South Carolina that this court of appeals, can make a determination of the law that South Carolina would apply, or this court of appeals can certify it to the Supreme Court if you want further assurances that what I'm saying is in fact what we believe to be the correct path. Or
Mr. Brown, excuse me, this is Judge Keenan. Mr. Brown, if we disagree with you that South Carolina law is clear on this subject, without having considered the case that you're now bringing to our attention, what about this new case resolves the issue in your mind? And if you could give us the citation to the new case as well.
Yes, ma'am. Yes, Your Honor. The new case is called Marshall, and it's actually cited in all our briefs. I cited extensively in my briefs, and it's called Marshall v. Dodds, and the citation for it is...
Oh, that's okay. If it's cited in your brief, I
yes,
thought
ma'am.
This was something that just came out that
no,
you
ma'am,
hadn't referred to before.
It came out after the district court ruled on this issue.
Judge Charles didn't have the benefit of it. That's what you're saying?
That is correct. Yes, sir, Your Honor. The district court did not have the benefit of it. And I cited Marshall v. Dodds.
What do you want us to do? What's your number one thing you want us to do? You want us to decide the South Carolina law is something other than what Judge Child said it was, or do you want us to certify it and get an answer from the Supreme Court of South Carolina if we can?
I believe you have the information in front of you to decide that decision, Judge, but if there's any doubt, I'd ask you to certify, because I think the law in South Carolina has developed in that clear of a fashion such that the ruling is going to be what I believe it's going to be.
Okay, but Mr. Brown, this is Judge Keenan again. Now that you've given us the cite to Marshall, Marshall's a medical malpractice case, isn't it? And you're talking about a tort there and the statute of repose. You aren't talking about a contract. I mean, I can see how you could make the argument it might foreshadow a recognition of continuous breach in contract cases, but it's just really extending the logic of Wilson, isn't it, in the Unfair Trade Practices Act case?
I think it is another step forward from Wilson. I think that may be the reason that we end up asking, if there wasn't the certainty there, to go forward and certify it, because South Carolina does not have a breach contract case directly on point. All of the breach contract cases in South Carolina that I have been able to locate are what I call single breach cases on executed contract. They're relatively simple contracts. I will tell you a couple of things with regard to this. Number one, in the South Carolina trial courts, which I do about half appellate, half trial, this issue comes up on a regular basis. It just has not made it to the Supreme Court. We see it in home building cases all the time. You have a breach contract. There is some breach in that contract with regard to the house, and the person determines not to bring suit. Under the logic of the district court's opinion and under the arguments being made by Novus, your failure to bring suit because the house wasn't painted buttercup yellow, and that was specifically in your contract, prohibits you from suing for breach contract 4 years down the road when you have a roof that was not built to the specifications and starts leaking. That is and it happens constantly in South Carolina at the trial court level where that issue is faced. So it may very well be that it's best to certify it, because we never seem to be able to get the right case up to the Supreme Court on that issue. They settle, and people don't take them on. I will say this with regard to Marshall and your recognition that it's a medical malpractice statute of repose case. I think it's interesting, though, that in Marshall, among the cases they rely upon is the Ortho-McNeil Unfair Trade Practice Act case. If you go back to the district court's opinion, Your Honor, the district court distinguished Ortho-McNeil on the sole grounds of, well, this is an Unfair Trade Practice Act case. We don't need to, it has no applicability because we're not dealing with an Unfair Trade Practice Act case. And the district court also talks about in the opinion, or in its order, that she could find no precise case on point in South Carolina. It's very hard to find a precise case, as y'all are well aware. So we have to look at the general direction often that a state is heading in. And if we go to Ortho-McNeil, it clearly said that with regard to fresh breaches, you may go ahead and bring suit for them under the Unfair Trade Practice Act. Our Supreme Court said with regard to Marshall, with regard to the statute of repose and medical malpractice actions, you may go forward and bring suit as to fresh causes of action, even though there's some stale ones out there. We know there's some that exceed the applicable statute of repose in that case, but you may go forward. And interestingly in Marshall, Your Honor, is the fact that the court looked to a Maryland case, Jones versus Key, and used that as the basis to come up with one of their conclusions, as well as they used Ortho in the Marshall case. I bring that up because, I'm sorry, does that mean my time is up?
That means your time's up.
I've got
bell, but
7 minutes over.
The sentence. Go ahead.
Yes, sir, Your Honor, and I appreciate it. I would just point out that this issue of whether or not they should have used this Maryland case, which was a statute of limitations case, to support a statute of repose, Justice Hearn, writing for the majority on our Supreme Court, said that's a red herring on these issues. So in this particular case, I believe that we have fresh breaches, and we should be entitled to go forward and sue on those fresh breaches. And I've saved 7 minutes for reply, so I appreciate the court's indulgence.
Thank you, sir. Ms. Mallory?
Yes, sir. Hello. How are you?
Good to have you with us.
Oh, thank you, Your Honor. And may it please the Court, my name is Jennifer Mallory, and I'm appearing today on behalf of the Novus appellees, and I appreciate the opportunity to appear before you today. Your Honors, the South Carolina statute of limitations analysis rests on twin pillars. And the first is the statute, which shows the legislative intent. And the second pillar is the discovery rule. In this case, we have a plain procedural 3-year statute of limitations which applies to breach of contract actions. The statute does not make allowances for complicated contracts versus simple contracts, or multi-party contracts versus two-party contracts. It is a statute that pertains to contracts, and it just provides for a 3-year statute of limitations, and that is the legislative intent. And then the discovery rule, Your Honors, is the second it's the second pillar of our statute of limitations analysis. And in South Carolina, it is settled that the discovery rule does not require actual notice or knowledge of the full extent of a claim. Rather, it only requires a party to act promptly to investigate the existence of a claim where the facts and circumstance indicate that one might exist. Not that it does exist, but that it might exist. And so, Your Honors, when we look at the case before the court today, Marshall versus Dodds, or the Ortho McNeil-Jansen case, all of those cases are viewed through this analysis, these twin pillars of the statute and the discovery rule. And, Your Honors, we would say that Marshall is an interesting case because the facts, as Your Honor pointed out, are distinguishable from this appeal because it is a med-mal case. And some of the law, of course, related to those facts are distinguishable from the breach of contract cases before the court. Nonetheless, Your Honors, the opinion in Marshall versus Dodds supports the district court's analysis in the proceedings below. And if it pleases the court, we would like to address those aspects of the Marshall opinion for your consideration.
This is Judge Harris. Can I just ask you a question about Marshall? It did seem that for the district court and before Marshall, there was an argument that was persuasive to the district court that you could make that I'm sorry, I think of it as the Wilson case, but the ortho med case just simply would not apply outside its statutory context, that it was based on that particular statute, the purpose of the statute, the text of the statute, and it would have no greater application. But then in Marshall, which comes out after the district court rules, you know, the South Carolina Supreme Court holds to the contrary and does extend it beyond its original statutory context. So why isn't that enough to, and I will just say that gives me some real pause. The district court didn't have access to that decision. At a minimum, we know that we're dealing with in the ortho case, not with a sort of one-off statutory decision. I mean, at a minimum, don't we need to certify this to the South Carolina Supreme Court?
Your Honor, we would say no, and the reason we would say no is that the only similarity in our view between Marshall and Ortho McNeil-Jansen, or honestly, if you'd rather call it Wilson, that would make me happy. but those two cases, the similarity is the focus of the Supreme Court on the applicable statute in both of those cases. So in the Wilson opinion, the court was looking at the Unfair Trade Practices Act, and its decision pertained to the per violation penalty, which was included in that statute. And what the court said there is that the language, and I'm quoting, the language of SCUTPA itself contemplates that an unlawful method, act, or practice may result in multiple statutory violations, and it is the violations themselves that cause the statute of limitations to begin to run. So the court there was focused on the per violation language. And, Your Honor, while it has been asserted by Polymed in this appeal that the district court placed some artificial restriction on the Wilson opinion, we would take issue with that, because the South Carolina Supreme Court is actually the court that placed a restriction on its decision. It said that SCUTPA statute of limitations begin to run anew with each violation. So not some other statute of limitations, but the SCUTPA statute of limitations. Now, in Marshall, Your Honor, again, going back to this concept of the twin pillars, Marshall was also focused on the statute that applied in that case. And the statute, as was pointed out, was a medical malpractice statute. That is a different statute than the one that controls in the breach of contract context. And
this is Judge Harris again. I mean, I absolutely understand your argument that these two cases, Wilson and Marshall, are distinguishable. I mean, if they weren't distinguishable, this would be a super short argument. But what I feel like I'm looking at is a Supreme Court that is increasingly willing to apply this particular form of the continuing violation theory across different contexts. And in the last two decisions they've had, they've applied it in two different contexts. And so it is hard for me sitting here to see how it's supposed to be clear to me that they would not apply it in this third context. Totally agreeing with you that it's a different context. There just seems to be sort of a momentum in this direction coming out of the court. And again,
Your Honor,
I didn't know that when it was ruling.
Your Honor, we would submit that there is not momentum. There are two different statutes that apply in Marshall and then in Northrop McNeil Jansen that underscore the importance of legislative intent to the court. And Your Honor, in Marshall, we would point the court's attention to the fact that Marshall expressly rejected the continuing tort type doctrine. So there's not, to the extent that there is concern that there's momentum, the Marshall court itself completely eliminates that concern. Because
sorry, go ahead, Judge Keenan.
I'm sorry, go ahead, Judge Harris.
No, you go.
Well, okay. Ms. Mallory, but that's a tort. Both of those cases we're talking about torts, and why, again, with regard to the issue of certification, we don't have any indication what the court would do in a contract case, do we?
Well, Your Honor, we would submit that you do. And the reason, again, looking at Marshall, what the court said there is that it was not willing to embrace a continuing tort type doctrine, and it was again rejecting judicially engrafted tolling principles.
Right, but contracts are very different from torts, as you know. And the tort obligation in the case of the statutes in Marshall and Wilson are imposed by statute. That is the violation of statute. The contract relates to the agreement between the parties. Why isn't that a material difference in your analysis?
Well, you're absolutely correct, Your Honor, that the statutes are different, and that's one of the important things here, is that we only have the legislative intent that we have before us with regard to the breach of contract claim is just a 3-year violation. It doesn't include the additional language that the Supreme Court took advantage of in the Wilson case. It doesn't have the additional language that the Supreme Court in Marshall had to deal with in the statute of repose context. So what the court was doing in both of those cases, and in both it said this, it was not willing to move away from what the legislature had dictated. So if the court has expressly embraced the concept that it must hew closely to the parameters that are imposed by the express language in the statute. We have no such parameters in the breach of contract context that would allow a court to add a new exception on top of the discovery rule exception, which has been applied in South Carolina. And so, Your Honor, the reason why I'm pointing to Marshall as supportive is that the court, again, rejects this continuing tort type theory, and Polymed.
I'm so sorry, Counsel, this is Judge Harris. As I read Marshall, and you can tell me if I'm wrong, and that would be helpful, because as I read Marshall, I thought they were actually, I agree, very clearly rejecting one form of the continuing violation doctrine, the one that treats it as a matter of tolling of the limitations period until one single giant tort is completed, basically, as in the medical context. But I thought the one thing your colleague was very clear about when he got up and in his briefs was that that's not what they're talking about here. This is different. This is not the pure continuing violation doctrine. This is the repeated violation doctrine where the old violations do drop out. There's no tolling of the original limitations period. It's just that the new fresh ones start a new statute of limitations running. So what I understood the South Carolina Supreme Court to be doing was to be distinguishing between those two forms of continuing violation doctrine. But do you read it differently?
Yes, Your Honor. So the concept that the South Carolina Supreme Court rejects when it is talking about its rejection of judicially engrafted tolling principles is a continuing tort type theory. And when Polymed made its arguments in support of this continuous violation, continuous breach type theory, it relied on Maryland law in large part. And under Maryland law, Maryland courts described this kind of continuing harm or continuing violation doctrine as applying to claims that are in the nature of a continuous tort. Well, that is the very principle that the South Carolina courts have rejected. They have left to the top.
It seems to me that what they adopted was, I don't know, I don't want to go down the rabbit hole of Maryland law, but what they adopted is exactly the theory that your colleague is arguing for here. Not the one continuing violation with the statute of limitations tolled until it's complete, but the repeated violation doctrine, the one they adopted in Wilson and in Marshall, where even though earlier violations are going to be held outside the statute of limitations, when there is a repeated fresh violation, the limitations period starts again. And they didn't reject that in Marshall, they adopted that in Marshall.
Your Honor, they adopted the language, they used the language of the statute, which says, and this is the part of the statute of repose, it wasn't the statute of limitations, it was the statute of repose, which of course confers a substantive right to a party, not just a procedural statute of limitation. But that portion, the substantive statute of repose, says that a med mal action must be commenced within a period, quote, not to exceed 6 years from date of occurrence, end quote. So the Marshall Court focused on those specific words that the General Assembly chose. And they stated, and again I'm quoting from the opinion, the statute clearly sets forth the triggering date as the date of occurrence. However, we note what this provision does not say, the date of first occurrence, end quote. So the court, again, was dedicated to following what the General Assembly had instructed, and it was not willing to ignore legislative intent and change the language of the statute of repose by...
Are you making a plain language argument? Is your argument that the plain language of the statute of limitations would sort of prohibit this repeated violation theory? Is that your argument?
Your Honor,
what's the language that would be inconsistent with the repeated violation theory?
I apologize. I submit that what the South Carolina Supreme Court says is that in these only two instances, in the Wilson case and in the Marshall versus Dodds case, that the court was driven by the specific language of the statutes that were before it.
And Ms. Mallory, this is Judge Keenan. What about the language from Marshall where the court says, we fail to see the logic in preventing an aggrieved party from seeking redress for acts that occurred within the repose period? It can hardly be said that acts of negligence that occurred within the repose period constitute long forgotten acts or omissions. I mean, if anything, doesn't that undercut the argument that you're making right here and seem to suggest that the court is open to the concept of continuing liability within the period, even though there has been long forgotten acts or omissions outside the limitations period?
No, Your Honor, and the reason is the exact language that you focused on, where the court refers to the repose period, the statute of repose section of the Med-Mal statute of limitations that confers a substantive right on litigants. That is not included in the breach of contract statute. So what we have here is a Supreme Court in South Carolina that is looking to the language that the General Assembly has specifically selected and is not willing to move beyond that. But it is also a Supreme Court that is saying, we mean this seriously. So we're not going to impose other judicially engrafted tolling principles, because this isn't a judicially engrafted tolling principle in the Marshall versus Dodds and in the Wilson case. And the reason it's not is that it came from the General Assembly. So the court is dedicated to maintaining the separation of powers and to allow the General Assembly to do its job. And we would submit here, Your Honors, that if the court were to decide that South Carolina, despite all of the case law to the contrary, were going to adopt a continuing breach theory, that would entirely change the law in South Carolina, and that is better left to the General Assembly. And the Marshall versus Dodds court has confirmed that by, again, rejecting the judicially engrafted tolling principles. And one issue that we'd like to address, Your Honor, that's come up, and just to make sure that this is clear, is there's been a question as to whether the continuing breach or continuing violation doctrine does constitute a judicially engrafted tolling principle, and we submit that it certainly does. And fundamentally, the doctrine would allow the court on its own to toll the statute of limitations by delaying the accrual of a cause of action related to the continuing violations. So it would allow a new accrual date for each violation rather than maintaining a single accrual date on the date that the earliest act was known or had reason to be known to the plaintiff. Now, Your Honors, again, Maryland law, on which PolyMed relies, recognizes this, that continuing harm doctrine flows from a continuing tort type claim. And so those two go hand in hand, but our Supreme Court, again, in Marshall, rejected the continuing tort type doctrines.
Anything else?
So, Your Honors, we're obviously happy to answer any questions that you might have, but just to quickly summarize, we would submit that, excuse me, Your Honor, that the district court properly exercised its discretion in deciding that South Carolina would not adopt a continuing breach theory. The district court...
This is Judge King. You said did the court have discretion to decide what the law is in South Carolina?
Your Honor,
has to decide the law one way or another. Has to view or figure out what the law is in South Carolina, doesn't you?
Yes, Your Honor, and the court looked to the available state law and determined that it was not clearly...
It's not a matter of discretion. It's not a matter of discretion in the federal court, Judge, to decide what the state law is. What you're saying is that you think that you won, so you wanted to... You believe she decided it properly, and you don't want a certification.
Yes, Your Honor. We do not want it to be certified, and we do think that she considered the appropriate law that was before her in making the decision, and that she had more than sufficient law, and in fact that the Marshall decision confirms that the district court made the right call when considering whether or not South Carolina courts adopt a continuing breach type theory.
I understand. Further questions?
No, sir.
Thank you, Ms. Mallory.
Thank you, Your Honors.
And Mr. Brown, you have reserved some time.
Yes, sir, Your Honor. And may it please the court again, I'd like to say a few things just very clearly so there is no confusion or misstatements on my part. One of the members of the court asked, am I trying to build up to one big violation? Absolutely not. I repeat what I stated earlier and what is stated throughout my brief. I am not seeking any type of judicial tolling or judicially engrafted tolling. I am looking for the right to simply bring suit for causes of action that fall within 3 years of my filing date of this particular lawsuit. With regard to the arguments about, well, Marshall is a statute of repose and that, vest even greater rights, etc. It seems to me that the fact that our Supreme Court in a statute of repose case, and statute of reposes are sort of absolutes out there, more so than a statute of limitation. A statute of repose is more of an absolute, more of a finish line, so to speak. This is it. And our court says in those cases, if you have claims that fall within the fresh period on the statute of repose, you're not going to face the issues we're concerned about, such as stale witnesses, stale evidence, stale things of that nature. And number two, the fact that our court was willing to extend the doctrine on a statute of repose case tells me that they are indeed, in my opinion, and I know it's just my opinion and I'm on the loss below, so of course it'll be my opinion, that they are headed in a direction of recognizing more and more of the essentially continuous accrual doctrine, which is that they're separate causes of action. You're not trying to get the one big cause of action. And so for that reason, I think Marshall is just very, very supportive of what we're doing here. Opposing counsel, who is my colleague and my friend, said that the district court fully considered the case law that was out there. I would ask this court to look at the essentially 5 to 6 cases that they looked at. As we know, Ortho McNeil was just cast aside based upon the UTPA arguments. But if you look at Ortho McNeil, our Supreme Court goes and looks at cases from all over the country, including some cases from South Carolina that have to do with issues outside of the UTPA, such as whether someone can sue for bringing tax credit suits and whether or not they accrue, or whether you lose those causes of action at a particular time. And in that particular case, they said, no, we're going to take this particular date you filed suit, go back 3 years, you can sue for your tax credits under a probate matter. So there is a wind blowing, in my opinion, for recognition of this particular doctrine. I would, again, also ask you to look at the Vieira case that the district court cited. It was cited for, I think, footnote 7, where they talk about the judge said he was looking for cases about a continuing wrong theory, and he couldn't find any. It's a complicated case. The fact pattern will drive, I think, even the most experienced appellate court judge up a wall a little bit. But when you get into it deeply, you discover it's an interesting case because Judge David Norton, very well, district court judge here in Charleston, had a case before him, and he did exactly, although it's not in a contract action, but with regard to a fraud claim and with regard to a malpractice claim related to legal malpractice, he said, here's what I'm going to do. Take the date of file and go back 3 years. You can sue for those things. Anything past that, I'm not going to let you get there. And that is in the Vieira case, which the district court cited as supporting the proposition that South Carolina would not adopt this particular case. The other cases all are tolling cases. Mayor versus T-Tex, which had to do with the pension plan, tolling. Anonymous taxpayer really wasn't even tolling. That was an impairment of contract case. So they said there was only one harm. Dillon County, again, a tolling issue. And then we had the companion property case, which Judge Curry looked at on a motion to dismiss. And this same continuous accrual doctrine was put before her there, and she said, well, I'm going to tell you what, I'm not going to dismiss this case based on that. In other words, she saw it as something that had potentially viability. So the cases relied upon by the district court, respectfully, do not support the conclusion that she reached on this matter. I think that you can take Marshall and you can go upside down with it, but I think one of the more interesting things, and I don't mean this in an inappropriate way, but sometimes briefs are more, tell you more about what they address as opposed to what they don't address. And if you look at Novus's brief, Marshall is not addressed in any detail other than for footnote 1, which says we oppose judicially engrafted tolling. And the other thing has to do with manufacturing. The evidence is undisputed. There are affidavits in the record that no manufacturing took place whatsoever until 2014. I filed suit in 2015. How those claims are barred, to me, is not consistent with South Carolina law. I will close with this comment. My client, and everyone's client is important to them, and I understand that. But it's a family-owned business, and they have these patents and these rights that have been taken from them, just out and out taken from them, and been told, hey, because somebody breached early and breached often, and because no action was taken on it, and there are a variety of reasons why action can and wasn't taken on it, you're stuck forever. You have lost your rights. Your property has now been alienated from you. You have nothing. And when you add to that the district court ruled, I'm not even going to get to the declaratory judgment with regard to whether or not the contract is terminated because there's no cause of action out there I can attach this to. That's not the law. If it is, it shouldn't be, and I think the issue should be put before the court on a certification. You asked the question to Judge King early what I wanted. I was a little greedy. You're right. There are no contract cases out there, and I think it's appropriate to let the court rule that matter.
Thank you, Mr. Brown.
Thank the court so much.
Thank you, and thank you, Ms. Mallory. We'll take your case under advisement, and the court will take a brief break before hearing the next case.
Thank you, Your Honor.
Very much.
You today.
Thank you.
The court will take a brief break before hearing the next case. Judges, I'm going to hang up and I'll call you back for the next case.
Thank you.
of the United States Court of Appeals for the Fourth Circuit.
Our next case is number 1930, Rodriguez Bedoya versus Attorney General Barr. Mr. Banas, good to have you with us, sir.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Brad Banas, and I represent the petitioner in this case. This court has held for nearly the last decade that credible death threats alone constitute past persecution. Here, Officer Bedoya provided credible, uncontested testimony about receiving various threats from the FARC in Colombia. And as such, he has demonstrated past persecution. And therefore, this court should grant this petition and remand this back to the immigration judge with instructions to continue proceedings. Since at least 2011, in a case called Crespin Vallardes, this court has made it clear that credible death threats are sufficient to qualify as past persecution for demonstrating asylum. Now, Crespin does not indicate that every time a government actor threatens the life of someone in passing, that constitutes past persecution. Instead, it's pointed that context is important. And Crespin and the progeny of that case have indicated a handful of things that this court tends to look at to determine whether a death threat is credible and sufficient to qualify as past persecution. The first factor they consider is whether the person communicating the death threat has the ability to follow through on it. In Crespin, it was MS-13, and this court noted that that particular group had a penchant for extracting vengeance on people. So obviously that group, a death threat coming from that group meant business. Second, whether there are parallel threats to family, that is, whether the threats go beyond just the individual applicant or to their family members. Third, whether the threats are isolated, distant from each other, whether they are repeated. And then finally, the method and means of how those threats are communicated, that is, in writing, in person, or even through other types of communication. And I would indicate that all of these factors, these context clues, indicate that the communications here to Officer Bedoya are indeed credible death threats that qualify as persecution under this court's law. And
Counsel, sorry, this is Judge Harris. Can I just ask, so is it your understanding that the BIA sort of made what we would think of as a fact error, that no reasonable fact finder looking at the surrounding contextual facts could have concluded that these were not credible death threats? Or was it more of a legal error that the BIA just didn't apply the law correctly?
Your Honor, I believe it's the latter, that they misapplied the law and they adopted a standard of death threats plus, which is what the agency here argues for in its response brief, that they are saying that you have to have a death threat plus some form of violence or harm to the petitioner or a family member or someone closely associated with them. And if you look at the language of the BIA decision, I believe it's on page 3 of the record here, they note that these were merely written, not verbally communicated threats, and that Officer Bedoya was never directly approached by a FARC member. And that seemed to be the support for their determination that these were not, quote, sufficiently menacing to be credible death threats under this circuit's precedent. So I do believe they apply a standard unknown to this circuit's case law that requires some sort of in-person or extra act for a credible death threat to be past persecution. And I do believe this comes from a recent decision out of this court, which is called Cortez Mendez, and the government cites it at the link, but it's really just one footnote there that Judge Agee put, and it's dicta. I think that court or that particular panel indicates clearly that they didn't need to reach the question of whether these death threats were persecution, but Judge Agee points out his concerns that here, those death threats, because they were distant verbal threats and that he was never physically harmed, he expressed that he was very dubious that that would constitute past persecution. And it seems to give credence to the government and the BIA's urging this court to adopt an analysis that is unknown to this court. And I think the better way of describing it is maybe those are factors, maybe those are context clues that would indicate whether these threats are credible or not, but it's not a separate eligibility criteria for death threats to constitute past persecution. And so I do think it is a legal error, Judge Harris. And I would just run through the facts here just to kind of put them in context. These are all written communications. If you look at page 466 and 468 of the record, you'll see the first two communications to Officer Bedoya where the FARC logo is on a piece of paper, and then threats that identify they know exactly who Officer Bedoya is, they know his exact history, and implicit in putting these under his front door is that they know where he lives, they know where he sleeps. And
was he a police
we argue
officer at the time?
No, Your Honor, he was not. He had retired after 20 years in 2012.
He was a retired police officer.
That's right, Your Honor. He had been with the National Police since 1992, and he even notes in his testimony with the immigration judge that for the first year of his retirement, it was pretty quiet. But in 2013, apparently the FARC had found him and noted that, and the first death threat, now that you are out of the police force, we will take care of the pending issues. That's a quote from the note they put under his door. So this is pretty typical, and the record has evidence that FARC does target former police officers, and it appears as though the FARC still had some outstanding issues with Officer Bedoya. And I would just note there are two notes that were put under his front door.
But the FARC was a revolutionary army, and they made a treaty or something with the Colombian government, hadn't they?
Your Honor, I believe that there were political talks between the FARC and the Colombian government to try to come to some peace treaty. In 2013, I believe that was a much more fluid situation than it is now, and that's the context we're talking about. And regardless, they had identified Officer Bedoya. They had identified why they were threatening him, and it was his prior participation as a national police officer. And the note says the matter on 1995 is still pending, which, as Officer Bedoya testified, in that year, one of his investigations led to the death of 3 FARC members. And apparently, they have a very long memory, Your Honor.
Mr. Bernal, this is Judge Keenan. Is there any evidence in the record, either documentary or testimonial, regarding how well this 2016 peace accord has held up over time?
Your Honor, I believe there are a couple of articles, but I don't believe there's anything definitive. I would point you to the records that start at page 185 and go through about page 300, which do contain the country reports and some news articles. But I would also suggest that may go to an analysis of whether my client can prove, or I should say, whether if we've shown past persecution, the burden shifts to the government to show that, to rebut the presumption of future persecution. And then if they can rebut it, then my client has the opportunity to try to demonstrate a well-founded fear of persecution. And if this court finds that he suffered past persecution, that's the end of the analysis. This petition should be granted, and it should be remanded back to an immigration judge, because the burden is then on the Department of Homeland Security to overcome the presumption of a well-founded fear of future persecution. And then I believe, Your Honor, that these questions of whether FARC is still a viable threat, it may be relevant. But for the issues that we have in front of this court at this point, I think that it's limited to whether these death threats are indeed viable. And
okay.
I do believe
and
that.
Let me follow up with another question. I don't mean to cut you off there. What about the passage of time between threats in 1995 and 2013? How do we factor that into the analysis that we need to apply?
Your Honor, I believe that the threats in 2013 alone are sufficient as credible death threats. In our brief, we don't rely exclusively on the 1995 death threat as sufficient. We point more to the series of messages between January and May of 2013. And of course, that 1995 is important. That 1995 death threat is important for context to point out what the FARC meant in 2013 when they said the matter in 1995 is still pending. But if we only had the 1995 death threat, I think it would be a very real problem for my client. But we rely on the series of communications, both in writing and in text message in 2013. And the 1995 incident is more to provide context and meaning to the repeated death threats in 2013. And I should note, the last one came on May 6th, and it said, "Let it be at the end of the month." And so my client's reaction was to leave by the end of the month. And he arrived in Miami on the May 27th because at that time in Colombia, he had subjective and objective fear that he would be murdered if he didn't leave. And again, this is asylum cases are very fact intense, and they have a lot of different issues. The issue in front of this court today, as the BIA limited it, is simply whether these written death threats can constitute past persecution. And I think under this court's consistent case law over the last decade, we see the BIA make a legal error by requiring more than just uncontested, credible death threats targeting him, and in very implicitly nefarious ways that are different than just walking by someone on the street. These folks knew where he lived, they knew where his children were around the country, and they made it clear what they were going to do. And for that reason, we would ask this court to grant this petition and remand this case back to the immigration judge for further proceedings. Thank you, Honors.
Thank you, Mr. Bannis. Ms. Al-Yusmani, you're representing the Attorney General. Good to have you here.
Yes. Thank you. May it please the court, my name is Eliza Al-Yusmani. I represent Attorney General Barr. I am a different attorney than originally wrote the brief, but I stand with the comments made in the brief. We agree with appellant that, or petitioner, that the 1996 is separate from the 5 threats in 2013.
Counsel, this is Judge Harris. Can I just ask you a quick question? The 1996 threats, they're still relevant, right, to give sort of context to the meaning of the threats that were slipped under his door in 2013? Or are you suggesting that we really can't look at them at all?
Oh, no, you can look at them.
Okay.
They give context for sure.
Do you feel like do you feel as though the IJ and the BIA looked at them for context? Because I didn't get that.
So I feel that they both looked at them because they were looking at a pattern and practice.
All right, but you would agree that if the IJ and the BIA had simply said, we're not looking at those were a long time ago, they're separate, and had not used them to give context to the meaning of the 2013 threats, that would be a mistake?
Yes,
okay.
I agree.
Thank you.
What I will say is that all 4, so this, the record does not compel the reversal of the agency's findings because Bedoya did fail to meet his burdens of proof. While threats of death alone can be sufficient to establish past persecution, Bedoya, I'm sorry? Hello?
You there?
Yep. Did somebody ask a question?
No, you go right ahead.
Okay.
I can hear you just fine. Go right ahead.
Bedoya only cites cases in which threats of death are actually stated, and there's a confrontation between the persecutor and the persecutee. So, for example, Crespin v. Valladores, there are similar threats under the doors. However, Crespin drove through Sonata and encountered one of his persecutors who shouted, "You need to shut up or we're going to kill you."
So your understanding of Crespin is that the court discounted the two threats that were pushed under the door. Those were not the threats. The only threat that really counted was the one that was face-to-face?
No, my argument is that those two plus a face-to-face.
And what do you do with the case, and I'm so sorry, I cannot remember the names, there have been so many, but the case where the gang sent the children into the store to deliver the death threats?
Hernandez.
And there was no confrontation with the gang member. Yeah, there was no confrontation with the gang member in that case, right?
I'm trying to, so I've got Farrah Holmes.
Sorry, I know you're,
I'm not sure that I have the case you're thinking of.
All right, I'll find it. You go on with your argument and I'll come up with it.
Okay, so same with Hernandez Avalos. So following
but counsel, Ms. Alicia Morny, when you look at Hernandez Avalos, the court is pretty categorically stating here on page 949, as to the first requirement, we have expressly held that the threat of death qualifies as persecution. We don't qualify the statement by saying the threat of death made face-to-face, or the threat of death orally, or there are no qualifiers on that statement. We say we have expressly held that a death threat qualifies as persecution. It seems to me that you're asking us to add something to our precedent. I don't see any language. You're talking about the facts underlying the holdings, but when you look at the actual language, point us to any language in our precedent.
I would have two statements to that. First, a death threat can definitely rise to the level of persecution. Here we've got some things that are vaguely threats, such that petitioner's counsel noted that there were 5 that constituted a death threat. There's no specific death threat. You can imply a death threat here, but that is that. But that the Hernandez Avalos doesn't make an explanation, and there's no explanation with as to what the death threat needs to look like. Is it slipped under a door? Is it face to face? Is it
isn't the implication that it really doesn't matter, that any credible threat of death is severe enough to rise to the level of persecution? The fact that it wasn't qualified is sort of the point.
We don't agree with that. I understand your point.
What is it? What part of that do you not agree with? What do you not agree with?
That with the death threats came face-to-face. That one was particularly horrifying. Following the husband's burial, heavily armed gang members came to her house and threatened to kill her if she identified the gang members to the authorities as the men responsible for killing her husband.
Counsel, it's just, sorry, this is Judge Harris again. The case I was thinking of is Zavaleta Policiano versus Sessions, in which the gang was sending children into a store with death threats. So there was no face-to-face confrontation with anyone scarier than a child. And I do want to say that even if I thought our precedent supported a requirement that a death threat be delivered in person, and I don't see that, I don't even understand the intuition driving it. It strikes me that coming home to your home and finding a note shoved under the door where you live is pretty darn scary, and maybe even scarier than sort of running into someone in public where you might feel less safe anyway, who says something to you. So I just don't, not only do I not see it in our case law, I sort of don't get what you're driving at. What is so, why would we attach some significance to whether a threat is made face-to-face rather than in a way that alerts the person being threatened that the person who is threatening to kill them knows where they live?
Because not all threats of death are to the level of persecution.
Right, and that might be true, but why would it matter in sorting through the ones that are credible and the ones that are not, whether they are delivered face-to-face? I'm just asking you, what is the common sense reason why, even though we have never before, we might be moved to adopt such a requirement in this case, that only threats delivered face-to-face and not those shoved under somebody's door may be credible?
Because that's what you have in your courts right now. There are no cases currently that say, I mean, obviously, Hernandez-Avalos does say it, but it doesn't rely on it. It doesn't say just because Mara 18 threatened them, it's good. It goes on to explain the substance of what happened. So, had they just said a death threat is, sufficient and stopped there, then maybe you would have case law that has that in the Fourth Circuit. But that's not what's happening right now.
This is Judge King. Is it your position that we have to say that a death threat constitutes persecution in order to rule against you?
No, but I would say that most of the other circuits do have a higher, a much higher basis or standard before getting to past persecution, and I can tell you a bunch of different cases if you're interested. But
that's okay. We're in the Fourth Circuit.
I know. Yeah, I would say that you're gonna have to. You would have to say death threats alone. But here, if you read the declaration on its own, so AR at 416, it is implied. I will agree with that, but so you're going to have to, when you write this new case law, you're going to have to include the fact that implicated death threats are, or implied death threats.
And implied that you're saying we're going to have to say an implied death threat?
Yeah. Like I said.
Do you question the source? The government, Attorney General.
Yeah.
Question the source? Do you think that this spark is too feeble to carry out a death threat, be dangerous anymore?
So the documents itself show that they're not going after policemen any longer. That FARC only hits military death or military and no longer police. And that's out of his own statements. And so I guess I'm moving forward. But yeah, if you read what's written, it is, there's no "I'm going to kill you."
Excuse me,
And-
counsel, this is Judge Harris. That's why I started at the very beginning with the 1995 and 96 explicit threats of death and asked whether those would give context when we look at 2013.
Those are not, those are third-party threats.
But they're expressed. They are expressed threats of death.
Yes, that.
Okay.
And you agree those that can be considered and that they put everything in context?
I do, but I don't think a third-party death threat counts as to. I was giving you I was saying that it works in context to say that somebody heard there was an issue and not somebody, but his friend, the farmer, and I would argue that he was killed because he lied, not because he was threatened, honestly. And so
I'm sorry, counsel. Just say that again. I just want to make sure I understand that the friend who warned the petitioner here of the death threat was murdered because he lied to FARC?
yes.
Okay.
Because he hadn't done anything that would get FARC on his back, except for lie to protect.
And so is the reason you're saying this because you think that Mr. Bedoya should sort of separate that out and be thinking like, look, FARC only murders the people who lie to them, so I'm probably fine here?
No, I'm not.
Okay.
Trying to be as ridiculous as it.
I don't understand what point you're trying to make.
I'm trying to make the point that there was no actual legal or written threat or oral threat other than a third party. So January 2013, Mr. Rodriguez, now that you're out of the police, we'll take care of that pending issue. We are returning to the area. The matters on 9/15/1995 is still pending. In March, another written note, same logo appearing under the door. You seem not to believe us. We're going to breathe in your ear. Have you heard the bombs in Savannah? You better know that we are close to you. Again, it's implying, but there's nothing in there that says. Then we get the text message saying, doesn't matter how much you hide, we will hunt for you, and if not you, we will catch one of your children, and let's see if you appear. So that's not a threat against his daughter. It's not a threat against him. So then he gets a second text on that day that says, we know your daughter is in Medellin. And at that point, he gets worried. And he is the one who says, I'm not hiding. He sends a text message to the petitioners, and he says, I'm not hiding. I'll be back in 20 days at the end of the month. And that's when the last one comes that I think is the most implicative of sincere harm. And that is, okay, then we'll see you at the end of the month. But that was in response to what he had said to them. If you look at page AR 416, his declaration attached to his asylum application. So here you've got implied, and even if you look at the opening brief at 7, the petitioner says there are at least 5 threats constituting death threats. He doesn't say there are 5 death threats. And even in the Fourth Circuit, you don't have you have a statement that says in Hernandez-Avalos you have a statement that a death, every court has a statement that a death threat alone can constitute past persecution. But you don't have any findings that they do.
Okay, but you're adding words to Hernando Zavalos. Judge Keenan, you agree, don't you? You're grafting can onto the words of the court at 949 when we said we have expressly held that the threat of death qualifies as persecution. We didn't say can qualify, we said it qualifies.
Okay, I would challenge you to find a case I guess this might be it, where just the threat without further intimidation or confrontation allows past persecution.
Well, you should look at Zavaleta Policiano. Unless it's the confrontation with the children with the notes.
Right.
That's the confrontation you have in mind that really notched that one up, is the children coming into the store.
I have it on here, I'm sorry. Zavaleta Policiano.
Yeah.
So that's a separate situation just because it didn't pass based on the nexus or type of, but the store received multiple calls, but also had direct contact.
But not with the gang members. It doesn't matter. I'm sorry, I didn't mean to interrupt you. Go on.
No, that's okay. My time is up.
Well, we appreciate your being with us and appreciate your help. Let's see.
Thank you.
And we're going to hear from Mr. Banis in rebuttals if he agrees with what you just told us.
Thank you, Your Honor. Just 2 quick points. My opposing counsel indicated that this court would be writing new case law if it found in favor of Officer Bedoya, and I think that this court would be simply reaffirming the case law that of this circuit that has been the case law of this circuit for at least the last decade, if not farther back to the Lee case in 2005. And the second point is just the emphasis of that case law is that context matters, and this idea that what I gather is that the government would prefer to have some sort of express "we are going to kill you" language in one of these threats is simply not required. And if we focus on context, right, things that do not say "I'm going to kill you" clearly are death threats. And the one example I can kind of think of is if I tell my daughter we're to go swim with the fishies, and by that I mean camp on the beach, that's not a death threat. But if Clark puts a note under Officer Bedoya's house or under his door that says you're going to be swimming with the fishies, that's a death threat. And so the exact words have to be seen in context, and I think that's what this court's long history of case law indicates. And I would just urge this court to apply that to the facts of this case and grant this petition and remand this back to the immigration judge for further proceedings. Thank you, Your Honors.
Thank you, sir. Thank you very much. Like both of you, we really appreciate your assistance with this case. And we'll take it under advisement. And Madam Clerk, it's time for another brief break before we hear the final case today.
Yes, sir. The court will take
Your
a
Honor.
break before hearing the next case.
Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our final case of the day is now ready to be heard. It's number 20-1160. Ms. Bunnell?
Thank you, Your Honors. May it please the Court, Amanda Mundell on behalf of the government. Thank you, Your Honor. This case involves challenges to an executive order and the State Department's implementing funding notice. The order, which can be found at JA 47, directs the Secretary of State to develop a process by which state and local government consent to resettlement of refugees is taken into account to the maximum extent consistent with law. The notice, which can be found at JA 51, implements that directive by asking resettlement agencies to gather consents for jurisdictions where they propose to resettle refugees. Nothing in the order or the notice supplants the State Department's ultimate discretion to determine where in the country refugees shall be resettled. Consequently, this Court should vacate the District Court's preliminary injunction because, contrary to the District Court's conclusion, the consent requirement described in the executive order and implemented by the funding notice does not give states or localities a veto over refugee resettlement in their borders. Now, plaintiffs focus most of their arguments on the notice, but I'd like to start with the executive order. Consistent with the Refugee Act, the executive order expresses the federal government's policy that the views of state and local governments are an important factor in deciding where to resettle refugees. And so it directs the Secretary of State to create a mechanism for taking those views into account. There's nothing inherently unlawful in that directive.
So, excuse me, this is Judge Harris. I don't understand that. There was already a system in place to take those views in account, and I'm just looking at the executive order. It doesn't say that the policy is that the views should be taken into account. It says that the policy is that refugees should be resettled only in those jurisdictions in which those state and local governments have consented. I mean, explain to me if this is just about making sure that views are taken into account, why it was necessary to do anything.
Certainly, Your Honor. So a couple of responses to that. And first, I think I direct Your Honor's attention to JA 47 under Section 1, Purpose, which describes how some states and localities have viewed the existing consultation requirement that exists in Section 1522 of the Refugee Act.
But then the operative section is Section 2, and the title is Consent of States and Localities to the Placement of Refugees. So it's just hard for me to understand. Is your argument really that this executive order is not about getting consent before there's resettlement?
Oh, Your Honor, we think absolutely the executive order addresses the fact that written consents should be gathered from states and localities. Absolutely. But again, going back just for a moment to that.
Is it your position that consent and consultation are the same thing?
Your Honor, we think that a consent requirement is a very clear way to obtain a state and locality's views. So, and that is something that would happen during consultation, but it's a way to clearly communicate whether the state or locality is able to accept refugees or is willing to accept.
Is it the government's position that consult and consent mean the very same thing?
I think as a matter of practicality, Your Honor, yes. And I think if we think, let me give you an example of why that sort of makes sense. You know, this court's local rules and many courts' local rules require attorneys to seek the consent of opposing counsel before they file particular motions or request particular relief from the court. And of course, that doesn't set up some type of veto over the court's ultimate decision on that motion. And likewise here, I think that's exactly what's going on with this consent requirement. It's not a, yes, refugees get to be resettled here if we consent, or no, they can't be put here if we don't give consent. It's instead just a means of clearly communicating state and local government's views. Now, of course, in consultation, conversations are broader than a mere yes, no on refugee resettlement. But as far as this requirement goes, it's not setting up a hard and fast veto over the federal government's ultimate placement decision. And so to go back to Judge Harris's question for a moment, under Section 1, the purpose of this executive order makes clear that there's a need for, quote, a more clearly defined role for state and local governments. And this is exactly the sort of clear mechanism that would provide
Ms.
that.
Mundell,
and so,
Ms. Mundell, this is Judge Keenan. Will the federal government then engage in consultation aside from the consent requirement?
Absolutely, Your Honor. That is the entire, section of Section 1522 discusses all of that consultation.
So you're
Nothing
saying
in
this is simply an add-on then?
It's a clear mechanism to sort of have these conversations at a very early point in the process.
Let me ask you a question. Something that's been really bothering me about this, and I guess it maybe reflects my background in state and local government law, but the executive order sets up a construct that is clearly unworkable in the context that a locality can withhold consent if a state consents. The locality in most states is nothing more than a political subdivision of the state. The locality can't withhold consent, and yet this order permits this. How do you reconcile it seems to me that the chaotic construct you have here, where you're putting the localities and the states at odds with their state constitutions?
Well, Your Honor, I think it's important to sort of recognize the practicalities on the ground here, and I think we only have perhaps a chaotic system if this court agrees with the district court that a mere consent or non-consent sets up this sort of veto power where no refugees get to go, and that's not how this operates. And so if a locality were to submit a letter to the State Department saying, we don't think we can accommodate refugees this year, and so we can't give our consent, but the state itself broadly says we welcome refugees in any of our locations, wherever folks would like to be. Again, this is important information that the State Department might consider among many factors listed in
Excuse me, Ms. Mundell, though, the Localities Act is a nullity under state law. Under the law of most states, the locality statement that they do not consent in opposition to the state statement that they do consent is a nullity. A locality is not authorized to act in contravention of the state because it's merely a political subdivision of the state and gets only its powers only derived from the state. So why doesn't that create a chaotic situation in implementation?
Well, and Your Honor, and I agree with you that states and localities have to have sort of this respective government, but at the end of the day, when a locality provides its consent, the locality is not providing some type of legal authorization for refugees to go there. It's merely a way to communicate to the State Department that they are willing or unwilling to accept refugees, and then it's up to the State Department in its discretion to consider that information in concert with all the other factors. And the fact that a locality may have a different
Counsel, this is Judge Harris. I don't see where you get that. Are you saying that under the executive order, if consent is denied, that is merely something that should be considered with all the other factors? And if so, where do you get that?
Absolutely, Your Honor, and this sort of gets back to a point that I would have liked to make to your earlier question, which is looking at Section 2B on JA 48. That section expressly acknowledges that the State Department can resettle refugees in non-consenting states.
Only if it can make a finding that failing to resettle the refugees within a particular locality would be inconsistent with the criteria established under law. Can you tell me what that even means? Let me just give you an example. Say Atlanta doesn't give its consent, even though Georgia did. So now we have this chaotic situation. Under the statute, you look at factors like, well, does Atlanta have the resources? Is there too much out-migration? What would it mean to say that failing to resettle a refugee in Atlanta would somehow be inconsistent with those statutory criteria? That's like a double negative that I don't understand.
Certainly. So I think in that example, Your Honor, if Atlanta says we can't accommodate refugees this year, the Secretary of State takes that information and it looks also at the other factors Your Honor highlighted, which, by the way, in case the court would like to follow along, the statute is reproduced at A1 of our addendum to our opening brief. And in that section, that little 3, subsection C3, it instructs the State Department to consider those other factors: employment opportunities, housing, whether right, and so all of those go into a bucket of of information.
But that's not what it says. The executive order doesn't say the State Department can resettle there resettle a person there, notwithstanding the lack of consent, so long as that would be consistent with those factors. It has to be, someone has to be able to say, if I put him anywhere but Atlanta, that would be inconsistent with the statutory scheme. How will that ever be the case? I just literally don't understand how this exception could ever be satisfied. It would have to be, right, that there is literally nowhere else in the country where you could put this refugee?
Well, Your Honor,
it wouldn't satisfy the exception as it is written to show that it would be consistent with the statute to put a refugee in Atlanta. It has to be inconsistent with the statute not to put him in Atlanta. And please explain to me the scenario where that would be true.
Well, that's right, Your Honor, and I think, again, this is a question, by the way, that occurs much later down the line in the process.
Well, can you just, this is a genuine question. Is there a scenario that you guys have in mind that would trigger this exception?
Well, Your Honor, I think, for example, if a particular refugee has a very strong community, family members or otherwise that are located in Atlanta, and that Atlanta has plenty of resources to care for that refugee and, set them up to be...
But how would it be inconsistent with the statute? There's nothing in the statute that says you have to go where you have friends or ties. If you can find some other city that has resources, it wouldn't be inconsistent with the statute to relocate the person there.
Well, Your Honor, I
think
it
might be more consistent to put them in Atlanta, but that's not what the exception says.
Well, another factor that's listed in the Refugee Act in that subsection is secondary migration, which of course could occur if the refugee is moving from one place where they have no family to Atlanta where they do have family. And so, I realize that there might be questions on the ground about once the Secretary of State gets all of this information, what the Secretary does with it. But as far as what the order requires, the order just requires the Secretary to develop a mechanism to get those consents.
Okay, but Ms. Mundell, what we have in the order is, it seems to me, totally reading out the relocation agencies. There is absolutely no mechanism that if an agency wants to override the consent the consent issue, how do they apply? There's absolutely no structure, no procedure. The Secretary of State issues this notice but doesn't address the procedure for applying the savings clause. So even if you have a valid savings clause, there's absolutely nothing in this that directs the resettlement agencies in how to go about it. It seems to me that this is like a one-off. This is like somebody's idea of something good to do without any thought as to how it's going to be implemented. And how can it be consistent with the Refugee Act when there is no provision for how the savings clause can be implemented, if in fact it is a savings clause?
Sure. So two responses to that, Your Honor. One, I think you're correct to sort of separate the executive order from the notice on this part. So when we think about that savings clause in the order and thinking about how the notice implements it, I think it's important to keep those separate. But second, you're correct also that the notice does not specifically say that when a state or a locality refuses to give consent, that these resettlement agencies can't apply. And in fact, I can tell you on behalf of the State Department that they will not reject an application merely because an agency has applied for a location that has refused to give consent. There's nothing in the notice that says they will reject that application, and in fact, practically speaking, they won't. And so,
well, the notice is suggesting, excuse me, Ms. Mundell, Judge Keenan again, the notice is suggesting like there's a provision for a rolling consent type thing. If you can't get the consent in the beginning, go ahead and apply and try to get it in the interim. But there still isn't anything that addresses what the agency must do for applying for so-called savings clause release. What does the agency have to do to get the Secretary to make a finding pursuant to Section 2 of the executive order that failing to settle the refugees would be inconsistent with the policies and strategies? What does a resettlement agency do with that? There's nothing in the notice that tells you what to do.
Well, Your Honor, what they do is they apply consistent with the notice, with all of their information, and propose those locations. And I will point out, at JA 55, the notice says very clearly that the State Department will evaluate, quote, all applications. at JA 62, it says, after discussing the fact that consents can be provided on a rolling basis, it says to resettlement agencies to document consents or their unavailability, and that no placement will occur in places lacking the documentation. But that's really all it says. And so to the extent that this court thinks
that's not all it says at all, counsel. It says at the beginning of that paragraph that they'll take into account the consents to the maximum extent permitted by law. And I have to say, it's not, I don't want to, I don't want to charge you with what's going on in other cases, but you're sort of catching me on a bad day, because I've had a long series of cases now where the government comes into court and tries to pretend that these executive orders don't mean anything. Like we're just spinning our wheels, we're just making noise, and don't worry, none of this actually means what it seems to mean. And I sort of feel like either defend this executive order, which I understand has a savings clause consistent with law and an exception that has not been operationalized by the agency and on its face doesn't seem to mean anything. But the point of it is to require consent. And the agency is clear that it will consider the absence of consent to the fullest extent permitted by law. So I feel like having a whole argument about whether an executive order that did something different and said, we just want to really confirm that everyone's having good consultations, and then we'll just throw that into the mix with everything else. I mean, we can talk all day about whether that executive order would be legal or not, but I feel like we're not talking about the actual executive order we have in front of us.
Well, so just a couple of responses to that, Chair. Number one, to the extent this court thinks that the notice hasn't, implemented that savings clause of the order appropriately, that might be a basis to enjoin the notice, but not the order. And just going back to the order then, it just simply does not set up the veto that the district court thought it did. And I want to remind the court that that is really what this case is about. It's not about ultimately what the State Department does with the funding. That is something that plaintiffs could challenge if their funding got denied through a subsequent action under the APA. The question here is merely gathering consents, merely asking states and localities if they say yes or no. Is that a veto over the federal resettlement decisions? And it's not set up like that, and in practice, it doesn't operate like that. So I agree, the executive order does something. It does make clear that gathering those consents is a priority and that taking those views is serious. But apart from that, Your Honor, it's really up to the State Department to finally make that decision, and that is something that hasn't yet happened. I think I have to reserve the balance of my time for rebuttal unless the court has additional questions.
Well, you can answer questions if you get further. And I have one I want to ask you. Are these issues being litigated in other courts around the country?
Your Honor, this is the only challenge that...
The only challenge is in Maryland and now in the Fourth Circuit.
This is the only challenge I'm aware of, Your Honor. Yes.
All right. And Judge Rossetti ruled against you.
That's correct.
He issued an injunction. Did he issue a stay order?
I believe it was just a preliminary injunction, Your Honor.
So it's in effect?
Yes. Yes. The State Department has not implemented the requirements of the notice. They've just continued to operate under previous cooperation agreements with the agencies.
All right. But it's possible that the election next week could have an impact on this litigation.
Hard to say, Your Honor, but right now the status quo has been maintained.
I understand. Yeah. Other questions?
Ms. Mondell, I've got one question. I'm trying to think about the practical applications of this and how it's going to play out. And there's a requirement that the executive of the locality consent, okay? So let's take a classic executive situation in Fairfax County, Virginia, where the county executive, okay, would say he consents, but the Board of Supervisors of Fairfax County is the body that appoints the county executive, and they override his consent. They say, no, you can't consent. You're subject to service at our pleasure, and we're dismissing you because you're exceeding your authority. We make those decisions. So then the executive is thrown out of office. what is the validity of the consent then that the county executive has tendered to the resettlement agency?
Your Honor, just in that specific circumstance, it's hard to offer a specific view, but I would point the court to guidance that the agency provided after issuing the notice that makes clear to the resettlement agencies that to the extent there's confusion over who can give consent or what locality qualifies or what executive qualifies, that they can actually work with PRM and the State Department to try to sort out that confusion.
But that's saying, you know, is there a county or is it a city? That's talking about identifying the locality, the proper locality. It's not talking about when the locality's legislative body overrules the executive of the locality who has appointed the executive in the first place. And I bring up this example because it just shows you the total confusion and chaos that nobody thought this through. It's just like an edict without consequence. It seems to, and it's so impractical when you think about operating on the ground.
Well, Your Honor,
and I'm worried about that.
Certainly, and I would go back to the point that this is not something that sets up, you know, a hard and fast rule on where refugees can go. To the extent that there is confusion or to the extent that consent cannot be provided because there's a lack of authority, I mean, this is just one piece of the puzzle. It doesn't destroy the other consultation conversations that happen under the Refugee Act. And the other thing that I would say here is that, you know, that real question about what happens on the ground really says very little about what the district court held with respect to this requirement, which is that just asking for consent creates a veto. As long as this court says that it doesn't set up a veto, the court has to vacate the preliminary injunction because that was the legal basis under which the district court relied.
Counsel, this is Judge Harris. I'm sorry to keep you. I just have a quick question on the APA claim. And I understand your argument that our APA review should be limited to the funding notices sort of discretionary components because, you know, we can't review the executive order itself under the APA. And I will assume for now that that is right. And the executive order leaves it to the agency to decide how these consents will be obtained and who will have to get the consents, whether that will be the government itself, the federal government reaching out for consents or not. So is there some place in the record that explains why the agency decided that it would put that burden on the resettlement agencies?
Your Honor, I think there is a declaration in the record that the district court did not strike, and that's at it starts at JA 208, declaration of Andrew Veprek. But in summary form, the reason it made sense to, you know, ask resettlement agencies to be the ones to collect those consents is because, number one, they're actually the ones proposing locations, so they know where they hope refugees can be placed. And number two, as even plaintiffs will acknowledge, they have extensive community contacts that the State Department really doesn't have in those local areas. And so they have the contacts already to start to have.
But Ms. Mundell, aren't you, Judge Keenan here, aren't you setting up a conflict with the statute, though, by putting this burden on the resettlement agency? Because the statute, Section 1522B, talks about the intent of Congress in providing this assistance is that social service funds should be focused on employment-related services, English as a second language, case management services. They're not talking about having the resettlement agencies have to dissipate the funds they get, which is what, $2,175 per refugee, on this consent process, when Congress itself wants to concentrate the money on employment-related services, English as a second language, and other specific things that have nothing to do with consent.
Your Honor, so I think the funding that these agencies get through this grant process is very different from their otherwise overall operating budget because this funding is just for initial resettlement. And I would point, Your Honor, back to Section 1522, Section C2, two Roman numeral, which actually does envision exactly a process where representatives, quote, of local affiliates of volunteer agencies meet regularly, not less often than quarterly, with representatives of state and local governments. So it is the case
to plan and coordinate, not to obtain consent as a matter of law.
Your Honor, it is true that the statute does not refer to the word consent, but this is exactly the circumstance that we're in, where we have these conversations and consultation conversations happening between these resettlement agencies, states, and localities, where they discuss the plan for resettlement. And so it's not inconsistent with the Refugee Act if the Refugee Act is silent regarding consent to then allow this to require the refugee resettlement agencies to initiate those conversations and ask for those consents.
It's your position that coordinate means consent?
No, Your Honor.
Consent means a lot of things.
Your Honor, I think the consultation meetings certainly in the past have allowed states to voice their concerns and to say whether or not they would be willing to accept refugees. So I don't think there's anything special about having a consent requirement happen in those consultations. That's something I think the Act envisions. It's just that this consent requirement provides a very clear mechanism for those views to be shared in writing at a very early stage in the process when all this planning and proposals are happening instead of farther down the line.
Counsel, this is Judge Harris again. I just want to make sure I'm clear on this. The declaration you pointed me to for the part where the agency considered, the agency's explanation for why it imposed this obligation on the resettlement agencies, that's a litigation declaration, right?
That's correct.
So there's nothing in
Your
the
Honor,
actual... Go ahead.
The only other thing I would say, which I think is maybe getting at your question, is that in the notice of funding at JA 62, the State Department says that PRM and ORR, quote, seek strong environments to support resettlement, speeding integration, and regard state and local consent to refugee resettlement activity as important evidence of such strength. So to the extent the court thinks that there's not enough explanation for why resettlement agencies were chosen to initiate those contacts, again, that might be a ground to enjoin the notice, certainly not a ground to enjoin the order.
Okay, but so in terms of something in the actual administrative record that would explain that choice, it's that sentence you just read me on page 62?
That's right, as far as, why resettlement agencies, as opposed to some other organizations, correct. Your Honor, unless there's any other questions, we would ask that this court vacate the preliminary injunction or at a minimum limit it to the three parties that are involved in this case instead of nationwide relief.
Thank you, Ms. Lindell. And you, Lindell, I'm sorry I mispronounced your name. And you've saved some rebuttal time. We're going to hear again from you. Mr. Cox?
Yes, Your Honor. Good afternoon, and may it please the courts. My name is Justin Cox. Thank you. It's good to be here, Your Honor. My name is Justin Cox, and I'm with the International Refugee Assistance Project. I represent the plaintiffs' appellees, Highest Church World Service, and Lutheran Immigration and Refugee Service. Your Honors, the district court did not abuse its discretion in holding that the plaintiffs are likely to succeed on the merits of their claims and that a preliminary injunction was warranted to avoid further irreparable injury and to restore the status quo as it has existed for some 40 years while the rest of this case plays out. Just to pick up on a few of the questions directed to Ms. Mundell, I want to start with consultation and consent. Consultation, which is a word the statute does use, is of course not consent. Consultation is a conversation, it's a dialogue. It's not a permission slip. If Congress wanted to require consent or to make consent a relevant consideration in this statutory scheme, it would have said so. But it didn't, and it didn't for good reason. Congress did, of course, recognize that states and localities can be valuable partners in the effective resettlement of refugees, but they were even clear that they can't stand in the way of refugee resettlement and that their preferences as to refugees being resettled within their borders is just not a relevant consideration under the statutory scheme. And we know, I also wanted to touch on the fact that we know right now that just as the executive order directs, refugee resettlement under the order will in fact be conditioned on the consent of both the state and a county official. And we know that most clearly from the declaration that Ms. Mundell referenced in her argument, the VPREC declaration, Mr. Vieprecht was in charge of implementing the executive order, and at the end of his declaration, paragraphs 10, 11, and 13, he explains in no uncertain terms that consent is required for the resettlement agencies to be able to resettle refugees in any particular jurisdiction. And
what page, excuse me, counsel, what page are you on in the JA?
Yes, Your Honor. So on JA 212 and 213. So in paragraph 10 on JA 212, Mr. Vieprecht describes consent as a requirement. And in paragraph 11, he makes quite clear that the role that consent is playing in this process. He states that if a resettlement agency has sought consent by January 21st, when the applications to the funding notice were due, but the consent hasn't been granted yet, they can still submit a proposal so long as they receive consent before the beginning of the funding period, which was to begin on June 1st. And he says as well that if, in the last sentence in paragraph 11, he states that PRM plans to maintain flexibility and to actually, if consent is withdrawn in the middle of a year, they will apparently adjust the placement plans solely on that basis. It's just demonstrating quite plainly that the role that consent is playing in this process. Now, I understand why Ms. Mundell on appeal wants to try to put some distance between the executive order and the funding notice, and to suggest that perhaps the funding notice was not in accordance with the executive order. But that's that's not an argument that was ever made to the district court, and so can't be a basis for holding that the district court abused its discretion. But it's also in conflict with the government's own briefing. So in their opening brief, they argue on page 21 that the agency was merely directly implementing the requirements of the executive order. On their reply on page 8, they say that the agency is simply carrying out the unambiguous import of the directives of the president. And so, and we don't disagree. We have never argued, never suggested that the funding notice is in any way inconsistent with the executive order. To the contrary, we believe that, as the government's reply on page 9 states, Mr. Vieprecht was trying to faithfully carry out precisely what the executive order required him to do. The issue is, Your Honors, that when Congress enacted the Refugee Acts, they carefully considered the role that states and localities could play in this resettlement program, and they expressly decided not to give them the authority that the executive order attempts to do. So, for example, you can see this all over the statutory scheme. So, for example, when a state decides that it wants to withdraw entirely from the refugee resettlement program, wants nothing to do with the administration or provision of services to refugees and their borders, there's a statutory provision that authorizes the federal agencies to designate a private entity to essentially step in the shoes of the state, such that refugee resettlement continues uninterrupted within that state. We saw this, most recently when Texas in 2015 sued to block the resettlement of Syrian Muslim refugees within its borders. That case was dismissed in June of 2016, and in response, a couple months later, Governor Abbott announced that he would withdraw Texas from the refugee resettlement program. And so the federal government arranged for another entity to step in, and refugees have continued to be resettled in Texas, notwithstanding Governor Abbott's clear objections, just as Congress intended. And Judge Posner made this same point in the Seventh Circuit case, the Exodus case, regarding then Governor Mike Pence's order to Indiana state officials that they deny services to refugees from Syria. And the executive order states in Section 1 that some states and localities desire a more defined role, but the fact of the matter is that Congress decided to give them precisely the role they have. This isn't a design flaw. This is what Congress intended. And there's no room here for the president to add additional requirements or certainly to undermine that congressional decision. Congress was...
Excuse me, Mr. Cox, this is Judge Keenan. I wanted to ask you, in order for you to prevail today, do we have to agree with the district court that this is a veto power that the executive order grants states and localities, or is there an alternative path to upholding the district court, and if so, what is it?
No, Your Honor, you do not have to agree with that conclusion to affirm, because there are a number of conflicts with the statutory scheme that don't depend on that conclusion. One, for example, is that the Congress stated explicitly in the statute that its resettlement provisions are to be uniform and comprehensive. And the executive order in Section 1 is plain that it is not enforcing the statutory scheme. Instead, it says that some states and localities think that the statutory scheme consultation scheme is insufficient, that they don't have a sufficiently defined role, and so he's going to order this sort of additional consent requirement. But Congress said that what it was doing was comprehensive, and there's no dispute either. Even the government does not dispute that. In fact, it's part of their position that if a particular state doesn't consent, that at a minimum that lack of consent will be taken into account. But that means that each state is going to be evaluated differently, simply based on a non-statutory factor. But what Congress wanted, and this is plain in 1522, is it wants the federal agencies to find the best match across the country of available resources and the needs of refugees. And it made explicit the factors that the agencies are to consider, and made sure that the states and localities have the opportunity to provide input. But ultimately, the decision is what's in the best interests of refugees. I think as well the executive orders, the other stated rationale that states and localities are in the best position to know the capacity they have for refugee resettlement. That also conflicts with the statutory scheme, because 1522A3 assigns that exact same responsibility to the federal agencies. They're required to ascertain what the state and local capacity is across the country, so that they can create this overall national plan, have an equitable distribution of refugees around the country, and more importantly, ensure that where refugees are placed, they are most likely to thrive, to integrate into their new home. And I think the other part of this too, Your Honor, that even if you don't agree that the consent requirement is an absolute veto, it also undermines the consultation scheme that Congress envisioned. As I mentioned before, that consultation is not consent, and really this, if you were to construe consultation to mean consent, that would have enormous consequences, given how common the consultation requirement is in the law and in environmental statutes and in many other contexts. And the case law is clear in that regard, that consultation does not mean consent. You don't have to get permission with someone who you're merely required to consult with. I also wanted to touch briefly on Judge Keenan's point about how the executive order disrupts the state-local balance that Congress struck. And I agree completely, it creates any number of practical difficulties. As someone who's sitting in Atlanta right now, I'll add further complications to the hypothetical. There are 29 counties in the Atlanta metro area. They don't have executives. We don't have county executives in Georgia. There's a county manager, but that person's not elected. That person is merely hired. And so there are lots of implementation issues. It's plain that no one thought through how this could actually work on the ground. The other the other issues that that we wanted to touch on very briefly, in terms of the arbitrary and capricious claim, although the government's argument is that it was merely implementing the executive order, there were a number of discretionary decisions that it made. The executive order required them to devise a process to get the consent of a locality, but it doesn't say what kind of locality. And the agency apparently decided that it should be counties, but they've never explained. Even on appeal, they've yet to explain why they chose counties instead of municipalities. And even though the record reveals, and this is at JA 106, paragraph 75, the record reveals that the agency did consider city entities from which consent could be obtained, but then they amended it about a week later to remove that. So they plainly considered it, but they've never explained why they chose counties instead of municipalities. And then, even the decisions that they tried to explain post hoc with the litigation affidavit, the VPREC declaration, it does not explain most of the relevant decisions. Even, for example, the unaccompanied refugees minor program, which the declaration mentions in paragraph 8, the point, the unaccompanied refugee minors program brings, as the name suggests, unaccompanied refugee children to the country, and that is the one part of the refugee program that is optional with states and localities. They have to opt into the unaccompanied refugee minor program, and it was pointed out to the agency. This is JA 202. It was pointed out before they issued the funding notice that state and local consent is already granted within the URM program, and so it doesn't make any sense to require this additional consent. And the VPREC declaration, although it claims that the agency took into account the unaccompanied refugees minors program, it doesn't actually address the issue that was brought to the agency's attention, as illustrated in JA 202.
Counsel, this is Judge Harris. I just have a quick question about the arbitrary and capricious and the claim and the failure to explain some of these decisions. Would the right remedy for that be enjoining just the funding notice and not the executive order? How does that get you to an injunction against the executive order? I don't think it does, Your Honor. I think to enjoin the executive order, you have to find that the executive order contravened the statute. Our APA claim is something of a backup, to be clear. I think our plain preference is that the court enjoin or affirm the injunction of the executive order itself. Thank you.
And in terms of the scope of the injunction, which Ms. Mundell touched on.
You're getting into what I wanted to ask you about that. Did you all litigate the scope of the injunction at all, or that?
Yes, Your Honor.
Just put that in there at the end. Pardon?
Yes, Your Honor, we did.
And you asked for a nationwide injunction?
Well, we asked that the executive order and the funding notice be enjoined in their entirety. We didn't ask for a geographic-based injunction because it doesn't really make sense in this context, because of the 9 resettlement agencies, their networks overlap geographically, and so it wasn't based on geography. It was based on the fact that our clients need that full injunction in order to be protected from the executive order, and the record is quite strong on this. But the biggest reason why our clients need it has to do with secondary migration and the fact that in some places the networks overlap and in some places they don't. So take Alabama, for example. Alabama has not consented to the resettlement of refugees. There's only one resettlement agency that resettles in Alabama, and that's Catholic Charities, which is a non-party. So if the injunction is limited to just our clients, that would mean that Catholic Charities could not resettle refugees in Alabama. And so if there is a refugee who has a family member who's already in Alabama or a pre-existing social tie that would ordinarily result in that refugee being resettled in Alabama. Instead, they're going to get resettled somewhere else. And then, shortly after they arrive, they will pick up and move to Alabama because that's where their network is, that's where their family is. And the record is undisputed that phenomenon, which is known as secondary migration, hurts everyone. It would hurt our clients, even though they initially resettled the refugees. It would waste all of their the investments in getting an apartment for them and helping them access other services. And so, regardless of the arguments about whether or not it was appropriate to extend the injunction to non-parties, I mean, the fact of the matter is our clients need an injunction of the executive order and the funding notice in their entireties just to protect themselves. And I think the other part about the other point to make on this is that, in the Refugee Act itself says that its provisions are to be uniform and comprehensive. And as the amicus brief of the non-party resettlement agencies notes, the Supreme Court has held that a court, when exercising its equitable authority, cannot ignore the judgment of Congress if it's deliberately expressed in legislation. And that's the Oakland Cannabis Buyers Co-op case. And so I think the district court was, in addition to, the district court is well within its discretion in fashioning the preliminary injunction that it did. But it was also narrower than, it wasn't particularly broad. It didn't try to micromanage the agency's work. Otherwise, it was explicit that the agency could issue a new funding notice at any time. And so we think at a bare minimum, the court did not abuse its discretion. And I think more, as my time is about to expire, I just wanted to.
Before the judge framed the injunction, did the parties negotiate over the scope of the injunction or anything like that? Or did the court have a conference or a hearing on the scope of the injunction?
Yeah, during argument, Your Honor, this is in the joint appendix. There was discussion of the scope of the injunction. We explained that we didn't think it was possible to have an injunction that was only limited to our clients, including because this is in this context where you have a funding notice where the federal agencies are going to decide which of the resettlement agencies to fund. We pointed out, how do you even have a practical or comprehensible? May I finish the question, Your Honors?
You answered this question, and any others you get, you answer them too.
Okay. Thank you, Your Honor. Yes, this was discussed at argument before the district court. The district court asked the government, how could you practically administer this program with an injunction that's limited to these three plaintiffs, given geographic overlap and the fact that you're supposed to be evaluating applications from all of them under the same criteria. The government conceded, that it will create problems, practical problems. It declined to say how those problems could be addressed or would be addressed, and just rested on their arguments. Just sort of the principle that a nationwide injunction is per se improper. I think the discussion of that started around JA 396, Your Honor.
Thank you. Other questions?
Thanks.
No, thank you.
Okay.
Thank you very much, Mr. Cox.
Thank you, Your Honors.
Ms. Mandel?
Yes, Your Honor, thank you. I'd like to make just a few points in rebuttal. I'd like to start with Judge Keenan's question of opposing counsel, where she asked if this court finds that the order and the notice don't create a veto, is there anything left that could support the injunction? And just addressing those 3 points that Mr. Cox made in response. You know, the first one is that he said that resettlement provisions under this act are supposed to be uniform and comprehensive. But this is a uniform process. Every state and locality's consent or non-consent is taken into account. The fact that that may lead down the line to more refugees going to one area or another may create a non-uniform placement of refugees, but that is always the case. Some states always have more refugees than others. So that's not a question of whether the policies themselves aren't uniform or comprehensive. Number two, he said that we have to look at 1522A3, which is the federal requirement to ascertain capacities, and that's not really directed to refugee agencies. But of course, the first response to that is that that statutory section doesn't foreclose resettlement agencies from being involved in this process of gathering consents. In any event, that is only an argument that's directed to the notice. It's not an argument for enjoining the executive order. And then third, he pointed out that this requirement would just destroy the consultation process altogether. But we would resist the notion that, as Mr. Cox characterizes it, that this is some sort of permission requirement that, again, overrides the Secretary's decision-making. Because once this court recognizes that this is not a veto, it's not as if once a state says no, refugees can't go, then it just becomes yet another factor, just like the consultation process that already occurs, that the State Department takes into account with the other factors enumerated in Section 1522 in determining placement.
Again, I do want to make sure I fully understand your argument, and maybe the best way to think about it is, like, I can imagine sort of three different regimes. Well, hang on. The one we have now, the one we had before the executive order, that's one. Another one would be what I think you are saying this executive order does, which is we're going to seek consent, and then we will just consider that along with all of the other statutory factors. It's just one more additional factor, and that's all. And then there's what I think, let me just say what I see when I look at the executive order, which is there is this exception or savings clause, which the executive order itself says is a limited exception. And just imagine hypothetically, it doesn't say that you will now look at the absence of consent as just one among every other factor equally weighted. It says that to the maximum extent possible, you'll not resettle people absent consent, subject to this limited exception, undefined in the funding notice, not operationalized anywhere, and which on its face says the exception will apply only when failing to resettle a refugee would be inconsistent with law. You're arguing for number two, that no, that's not what the order says. It says that you'll just consider it along with all other factors. If I think hypothetically, it's actually the third one I described. There's this limited exception that on its face applies only when you can show that not relocating someone to a particular place would be inconsistent with the law. The law requires that they be located to that place and that place only. Where are we then? Is that a veto power or no? Or would you say that's still not a veto power? There's still, if I think that that's all the exception does, is the government right anyway? Because that's still not a veto power? That's what I'm trying to get at.
Yes, Your Honor. We would still say that that's not a veto, specifically because, again, the discretion rests in the Secretary's hands. And just to, and so as a result, even if you read that provision narrowly, the district court still gets it wrong here in enjoining the order and the funding notice.
Okay, Ms. Mundell, this is Judge Keenan. What happens, in your view, if every state and locality withholds consent? Why doesn't that create a problem, undermining the Act's purpose of resettling refugees? Nobody will take them. I mean, your whole argument seems to assume that somebody will take them. But what if nobody does? Where are we left?
So, Your Honor, I mean, again, we would resist this notion that when a state says no, that refugees can't be placed there. It's really just communicating their recommendation or their preference in a clear manner. And we can talk about the real numbers on the ground here because, in fact, in the short while that this notice and executive order were up and running, plaintiffs were able to gather consents from 42 out of 43 states. and over 100
right,
localities.
but I'm asking you about the hypothetical, because we've got to consider exactly how far this could go if we approve it. And what happens if every state and jurisdiction withholds consent? What happens to the Act's purpose of resettling refugees? Does it just go by the boards? I mean, what happens?
Well, Your Honor, again, even if every state and locality in the country said we're not willing to accept refugees, this refugee resettlement process continues under the Refugee Act because, of course, not taking any refugees when they have been approved and when there are places with, employment opportunities and housing, that would be inconsistent with the Refugee Act. And that is exactly what the executive order says. Failing to resettle refugees in that jurisdiction would be inconsistent with the Act or otherwise applicable law.
So you're saying then the consent requirement would be nullified by the executive order?
Well, that's exactly what that savings clause does. Consent only goes so far as it, doesn't run up into any problems with existing law or if it's inconsistent with those other factors that are mentioned in the Act. And so if that's the case, then of course, that's going to affect the weighing of that factor. But again, it's not a veto problem. It's just a relative weight of these consents or non-consents in those other factors. That is something that's committed to the Secretary's discretion later down the line. And at this stage, the question is really just...
So you're saying the savings clause as a matter of law can nullify the consent requirement?
I guess I'm not sure if I understand the court's question, but I think the answer to your question, Your Honor, is just this savings clause in this order makes clear that the Secretary's decision-making process is preserved under the Act.
Okay, so but could you answer the question, can the savings clause nullify the consent requirement? You seem to be saying, yes, it can.
I'm not sure what the court's asking with respect to nullify. I mean, if placing a refugee in a particular area that hasn't consented would accord with the Act, then the consent, probably played very little role in the process. I don't know if it's something that nullifies the requirement. It's not a veto, so it's not something that really gets nullified.
Right. Well, this seems your reasoning, and I guess I should let you know what I'm referring to here. The City and County of San Francisco case, 2018 out of the Ninth Circuit, they seem to be rejecting the analysis that you've given and talk about savings clauses have to be read in their context. And they cannot be given effect when the court, by rescuing the constitutionality of the measure, would override clear and specific language. And it seems to me that there's just an internal conflict in your position that is analogous to the one pointed out by the Ninth Circuit in City and County of San Francisco, 897 Federal 3rd 1225.
I think I see what you're saying, Your Honor. And so if I can just explain, Section 2B here really just says that, there's got to be a mechanism to gather consents and non-consents. And then it says should. It doesn't say shall. It says should. These refugees should not be resettled in those localities that don't consent unless failing to do so would be inconsistent with law. And that, I don't think, creates the sort of conflict that the San Francisco case was really looking at. That is something that speaks to a very real consideration by the Secretary of State that once it has these consents or these non-consents at hand, what it does with that with respect to the other factors. There's really no nullifying or conflict there. It's really communicating that the Secretary retains the discretion to make that decision holistically.
So I guess you would so much rather be up here defending an executive order that said they should not be relocated there unless the Secretary, considering all factors in the statute, thought that was best to relocate them there. But that is so not what this executive order says. And people draft these things really carefully. They did not say unless it would be consistent with the statute to relocate them over the jurisdiction's non-consent. And I still, we did sort of get to an answer toward the end, that it might be inconsistent with law not to resettle a particular refugee in a particular place if everybody had said no, and so there was nowhere else to put them. But short of that, I mean, they picked this, people choose the language in executive orders with great care, and they did not write it the way you are defending it. And so I just keep getting caught in this, would that it were written the way you are defending it, because then I think you would have a much easier case. But that's just not what it says.
Well, Your Honor, and I apologize if, yeah, and I apologize if I'm being imprecise or if I'm sort of, conflating the language, but I think, the court's question is really getting into the relative weight of this factor among the others. It's not a question of whether just having the consent is a veto, right? And that's really what's going on here, because if just gathering the consent were all you needed, there would be no reason to include that savings provision in the executive order at all, because then the executive order would have to stand for the proposition that once you have the consent, that's all you get. Really, what this executive order does in Section 2B is to say that, after you get these consents, and if you're going to resettle a refugee in a place that hasn't consented, you have to look at the factors. And if failing to put them...
You keep saying it really... We will just have to agree to disagree about this, but I'm sitting here looking at it, and it just doesn't say that. It says you have to, before you decide you're not going to send this refugee to the locality that didn't consent, you have to make sure that not sending them to that place would not be inconsistent with the factors. And I just don't see how sending them somewhere else would be inconsistent with the factors. I'm still finding this to be a null set, and I know you want to push that down to sort of how this will play out in operation. But if it's a null set, then there's sort of a problem on the face of the order, I think. That is my concern.
And so, Your Honor, the only thing that I was going to say just briefly before that was that, the order clearly does direct the Secretary to look at those factors. It references the factors specifically. So, of course, the Secretary has to look at them. Now, when the language says failing to resettle refugees within that state or locality would be inconsistent with those factors, it plainly contemplates a process where the Secretary considers those factors and then thinks about whether not putting the refugee in that location is inconsistent with those factors. And that is enough to defeat this idea that it is a veto, because that shows that the Secretary of State retains this discretion to determine whether it's inconsistent. And there may well be a number of reasons why it could be inconsistent. Thinking about secondary migration, this holistic factor, and I'm quoting the language here, subsection C3, big Roman numeral 3, the likelihood of refugees placed in the area becoming self-sufficient. This is a holistic, process that does not, at a granular level, unlike I think what Mr. Cox said.
Okay, so I promise, I know I apologize to everybody involved, because if I could understand this, it would be helpful. So, okay, that factor is the likelihood that they would be self-sufficient. So the Secretary would say Atlanta is consented, but I'm looking at Atlanta, and I think they would likely be self-sufficient in Atlanta. But that doesn't mean that it would be inconsistent with that factor to resettle them in, say, New York, if they would also be self-sufficient in New York. And so that's why I'm having, I don't see how looking at a factor like that, you could ever find it would be, just because it would work in Atlanta doesn't mean it would be inconsistent with that factor to put them somewhere else.
And Your Honor, on the ground, that might be the case in, certain circumstances, but of course there's a very, real likelihood on the other end that it's not. I mean, likelihood is not an on-off switch. Likelihood already implies some type of degree of likelihood. And so, again, if Atlanta is a place where the refugee has, numerous contacts, there's plenty of employment opportunities, it may be the case that really nudges that likelihood of success, much greater. And so it would be inconsistent in that circumstance to perhaps place them, somewhere else. And I would say, by the way, Your Honor, that, there have been times that the State Department has been told by states and localities that they just really have grave concerns about resettlement in a particular year and that they don't think that they can support it. And the State Department has never, only on that basis, determined that placement should or shouldn't occur in that location. So this is something that the State Department is equipped to consider. And so when we're thinking about what is or isn't inconsistent, I mean, this just really gets into the Secretary of State's discretion. It's really not a question of whether just asking for those consents automatically creates a veto. Because if there's any chance that it doesn't, then plaintiffs haven't established their likelihood of success to support this injunction.
Thank you. Sorry. Thanks.
Ms. Mundell, we appreciate your work in this case and your fine argument, and also that of Mr. Cox. You've both done very well, and we very much appreciate it. And if we were in Richmond, we would at this time leave the bench and come down and shake hands with each of you and congratulate you on the job that you've done. What we'll have to do in these circumstances, Madam Clerk, is we'll take the case under advisement, and the clerk will adjourn court until tomorrow.
Yes, sir. This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.
Conference recording has stopped.
Judges, I'm going to hang up and I'm going to call you back to the conference.